What's going on, everybody? AJ here with the Blue to Green. Breaking news. The Supreme Court of the United States of America has come out and given their opinion on the United States versus Hemani court case that came out of Texas. I'm going to give a real quick breakdown as to what that is. A gentleman was arrested for possession of a firearm while admitting to being a cannabis user. It worked its way through the Fifth Circuit Court of Appeal. It went through Texas, the Fifth Circuit Court of Appeals, ultimately ending up at the Supreme Court of the United States. Today, they have given their opinion. Today, all 9 justices of one of the most arguably conservative Supreme Courts ever has all stated that the United States government, the Department of Justice, federal agents do not have the lawful authority to arrest and prosecute a person, a citizen, based upon having a firearm and being a cannabis user. So I'm going to give a breakdown. I'm going to explain where I got the information from, what I did, and I am reading from a script so I don't screw this up. So before I start, this case just came out today. This is breaking news as of today. Where I got the information from is I went directly to the Supreme Court's own docket and I read the entire opinion. I read every single word of it. It's lots of words, it's lots of things, lots of legalese, and got an explanation as to what happens. Then I took all of this information, I put it into an AI model called Notebook, and it gave a breakdown. And if you're not familiar with Notebook, it doesn't pull from anywhere else other than the resources you tell it to. So it didn't go outside and find BS and all that sort of stuff. It's just the information that I gave it directly from the docket, and I'm not going anywhere else. A couple things. I'm not an attorney. This is not legal advice. This is just my own personal breakdown as a prior law enforcement officer, explaining to you what the Supreme Court, the highest court in all of the land, said in regards to cannabis consumption and usage and the Second Amendment and firearm ownership. So let's go over this real quick, okay? What started as an FBI case, Ali Hemani was, his home was searched on a terrorism-related investigation. I didn't go into any of that. I didn't research any of that. I have no information on that. That's completely besides the point. Hemani was fully cooperative. He handing over a gun that he was kept in the house and also told the federal agents, hey, there's cannabis inside of the house, marijuana. During the interview, he admitted that he used marijuana about every other day. The terrorism suspicions were unfounded, but 6 months later, the government indicted Hemani on a single charge, knowingly possessing a gun in his home while being an unlawful user of a controlled substance. That is Title 18 USC, Title 922, Paragraph G, or Section G, Paragraph 3. It's all big legalese. Okay, so the government did not claim he was an addict. They did not claim that he was under the influence, the current influence of cannabis. They just said, you are using a controlled substance, you are in possession of a firearm, boom, automatically illegal. And that is the way it has been across this country for years, since the dawn of time. You could not be a cannabis user and legally own a firearm at the federal level. Couldn't own it, couldn't have it in your home, couldn't use it, couldn't anything like that. So if you've been watching me for a little bit, you'll understand that I believe in all of our rights, including our Second Amendment right. So with that being said, let's continue on with the case. They did not claim he was an addict, nor that he was intoxicated, or he wasn't handling the firearm, or that his drug use made him a danger to himself or others. They alleged that his admission and regular marijuana use alone was enough to send him to prison for up to 15 years and permanently strip him of his Second Amendment rights. If we remember, the Constitution does not give the government authority. It keeps the government's paws off of our God-given rights. It is stating that we are allowed to have, these are our inalienable rights, and the government is not allowed to infringe upon those rights. All right. The government prosecuted Hemani under 18 U.S.C. Title 922, Section G, Paragraph 3, a federal law that automatically bans anyone who is an unlawful user or addicted to a controlled substance from possessing a gun. Because marijuana remained a controlled substance under federal law, the government argued Hemani was legally barred from the gun ownership. Just the ownership, just having it in his house. To justify disarming a citizen under the Second Amendment, the government must prove its law aligns with the nation's historical tradition of firearm regulation. So the government prosecuted him, they appealed it, it went to the Fifth Circuit Court of Appeals, which was the court that covers Texas, which this case is out of. Ultimately, it got sent up to the Supreme Court. So To meet this burden, the government pointed to an 18th and 19th century habitual drunkard laws. Again, I read this entire court docket. I read every single word that came out of this case. And the government was basically going back to habitually drunkard laws, being a drunk. And if you read through the actual docket and the opinions, the justices themselves say like this. They basically stated in very layman's terms that the federal government did a terrible job and a really shitty job of trying to make this case. And they would have said, under how they were trying to present it, our forefathers would not have been able to have their Second Amendment. They would not have been able to have weapons. The habitual drunkard law is supposed to be for those who cannot control themselves any longer, who have lost all faculties of their mental state, who are unable to take care of themselves, unable to take care of their business. Not just people who drink. They even stated in the opinion, this is not for people who drink every day. It is not for those people. If you consume alcohol every day, that does not make you a habitual drunkard. These are and it also talks about how our forefathers, I forget who, but I think it was John Adams or George Washington or one of them old guys, would drink a pint of cider in the morning and a pint of whiskey at night, and that still was not considered a habitual drunkard. So anyways, moving on. They argued that early American vagrancy, civil commitment, and surety laws restricted the right of habitual drunkards because their regular use of intoxicants made them unusually dangerous. The government reasoned that just like those historical drunkards, regular marijuana users are a categorically dangerous class of people who should be disarmed to protect the public. What? How many millions of Americans are currently consuming cannabis on a regular basis? Again, I'm not sorry. I don't want to go down the side path here, but that's just utterly ridiculous. The Supreme Court rejected the government's argument, ruling that the prosecution of Mr. Hemani was unconstitutional. For everyday Americans who use marijuana but do not abuse it, the decision establishes significant legal protections. The court pointed out a major flaw in the government's historical reasoning. Early Americans is what I'm talking about. Early America had a culture of copious drinking, and founding fathers like John Adams and James Madison drank daily. Historical laws did not target people simply because they consumed intoxicants regularly. Rather, they targeted habitual drunkards whose extreme abuse of alcohol rendered them practically incapacitated and incapable of managing their affairs. That doesn't mean even if you get blackout drunk every night. That just means if throughout the day you're drunk more than you're sober. That's what this basically boiled down to in regards to the habitual drunkard laws. All right. So because of the government's application of 922 G3 sweeps of anyone who regularly uses marijuana, regardless of the amount, potency, or effect it has on their daily functioning, it went far beyond historical bounds. Practically, this means the federal government cannot automatically strip you of your Second Amendment rights simply because you are a regular recreational marijuana user or a medical user. However, the court explicitly noted that this is a narrow decision. The ruling does not protect you if your marijuana use crosses the line into abuse. I don't disagree with that. I don't disagree with that with any drug. I don't disagree with that with alcohol. The court left the door open for the government to disarm individuals who are genuinely addicted, those who are actively intoxicated while possessing a firearm, or those whose specific drug use can be individually proven to make them a danger to themselves or others. Okay. So when it comes to cannabis, it has now been, medicinal cannabis has now been put into Schedule 3, stating that there is known medicinal values, which the science and research needs to continue on to prove that. How do you prove active intoxication with cannabis? This is something that's still in the works. Researching, states are trying to do this for DUI laws. Oh, just because you have metabolites in your system, are you under the influence? Are they active metabolites? Are they inactive metabolites? Again, there's so much nuance to go with this. But at the core of what this states is that just because you use cannabis, you are allowed to have a firearm, and the federal government is not allowed to disarm you, arrest you, and prosecute you simply for having a firearm and consuming cannabis, recreationally or medicinally. Now, I went on to ask it the question. I said, can someone have a firearm on their person while carrying in a legal capacity while admitting to being a marijuana consumer, as long as they are not actively under the influence? So going through this, it says, yes, under this ruling, an individual who regularly consumes marijuana can legally possess a firearm, provided they are not actively under the influence or proved to be a danger to themselves or others. The Supreme Court described this distinction through several key points in the ruling. The difference between regular use and active intoxication. You should not be stoned. You should not be under the influence of any drug, any substance, anything, Benadryl, codeine, cocaine, anything that alters your mental status and be possessing a firearm. I agree with that. I 100% agree with that. We can talk all day about sugar and caffeine and blah, 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 but you understand what I'm talking about. Like things that are classified as drugs. Cannabis is a drug. Cannabis can intoxicate. Cannabis can also medicate. So if you're medicated and have used cannabis, if you've used cannabis and you're medicated, does that mean you're not allowed to have a firearm on you? I can't answer that question. Again, not legal advice here. If someone takes their Vicodin and they're prescribed a Vicodin and they take it as prescribed, they put their gun inside of their waistband and they head out the house. Next thing you know, they're out with their family and they get involved in a good, clean shoot that is ruled justified and saves the day and saves people's lives. Are they going to be prosecuted for using a controlled substance? No. So I'm going to say that in situations like that, I think you'd be okay. Again, not legal advice. If you were stoned to the bone, you're sitting on your couch, you've got the munchies, you want to run up to Circle K real quick, you put your gun inside of your waistband and you run up to Circle K, that's irresponsible. You should not be doing that. Again, there's a time and a place. That's, as I've said from the very beginning, in regards to my personal thoughts on this, it's with intention and purpose. I'm not a recreational user. I use it to medicate for back pain and all this and other things. So that is my personal stance on that. But anyways, moving on. The court emphasized the historical firearms regulation habitual drunkard laws did not disarm citizens because they regularly consumed intoxicants. Given the culture of copious drinking in early America, the court noted that historical laws only targeted individuals whose extreme abuse rendered them practically incapacitated and incapable of managing their affairs. Therefore, automatically disarming a person simply because they are a regular marijuana consumer without showing they are incapacitated or a threat goes far beyond the nation's historical traditions. The narrow ruling, the Supreme Court explicitly described in its narrow decision that drawing a firm line at active intoxication. Again, how is the federal government going to prove active intoxication? Great question. Excuse me. The majority opinion states, we do not address efforts to ban addicts or those presently intoxicated from possessing a firearm. This means the ruling protects your right to possess a firearm as a marijuana consumer, but it does not protect you if you are carrying the firearm while actively under the influence. Okay, please get that through your heads, everybody. Please don't smoke a J, then go carry your gun and think you're going to save the day. Lack of misuse or dangerousness. The court criticized the government. Oh man, if you read this opinion, they criticized the hell out of the government. They're like, you guys failed miserably. The court criticized the government for prosecuting Mr. Hemani solely based on his admission that he used marijuana about every other day. The court pointed out that the government made no effort to prove he was ever intoxicated while handling his firearm, that he was an addict, or that his specific drug use made him a danger to the public. By the way, again, this whole thing started, again, I didn't dive into the very beginning of the case. The FBI raided his house because there was the threat of terrorism or terrorist activities or a link to terrorism, whatever, I don't know. But none of those charges stuck. He wasn't even charged with terrorism. He wasn't charged with anything. After the FBI did their raid, after they found the crime, then they pinned it on the person. I'm sorry. Yeah, that's what happened. So they weren't going looking for his guns and looking for his marijuana. They were going looking for something else, found this, and said, we didn't find the terrorism stuff, so we'll just charge him with this. FBI is kind of famous for that. They find the person and then find the crime later. Sorry. The court pointed out that no proved that he was ever intoxicated. It noted that it makes no difference to the government's flawed theory if a user keeps a firearm only in his home for self-defense, never misuses a gun while intoxicated, and never poses a danger to himself or others. Leaving the door open for individualized proof. While everyday recreational use is protected, the court clarified that the government might still be able to disarm a marijuana user if it can provide individualized proof that the defendant's use of marijuana renders him or her a danger to themselves or others. Ultimately, the ruling affirms that the federal government cannot automatically strip you of your Second Amendment rights just for being a regular marijuana consumer, but it strictly preserves the government's ability to regulate or prosecute individuals who possess firearms while actively intoxicated. I then went to continue to ask it, read through this and clarify. Can I carry a gun? Can we as Americans carry guns outside of our home? Remember, our home is our castle. We have a lot of protections as Americans inside of our home. Excuse me. I asked it, let's break it down. Let's look through this. Can Americans who consume cannabis, not actively under the influence, consume cannabis, carry their weapons in a legal fashion outside of their homes? If you live in a constitutional carry state, are you constitutionally allowed? I have my own opinions on constitutional carry, which I think should be across the state, the country. But anyways, I'm very pro Second Amendment. I very much condone everybody exercising their rights. I asked it, can you carry it with you? Can you have your weapon with you? Can you leave your home? Can you go about your daily life? Let's break down the case and let's see what it says and let's see where the flaws are. Again, this is not legal advice. Yes, under the logic of this ruling, an individual who regularly consumes marijuana can possess and carry a firearm outside of their home as long as they do not carry it while actively intoxicated. Mr. Hemani's specific case involved a firearm kept inside of his home. The legal reasoning that led to the dismissal of his charge centered on the distinction between being a regular user, and being under the influence while armed. The historical bans on carrying, the lower court rulings that set the stage for Hemani decision noted that historical intoxication laws focused precisely on the issue. History and tradition supports laws that ban individuals from carrying weapons while under the influence. However, these historical laws did not impose a blanket ban on firearm possession or carrying for people who were simply regular drinkers when they were sober. Again, our forefathers were drunks. The limit is active intoxication. The Supreme Court explicitly stated that its ruling is narrow and does not prevent the government from enforcing laws that ban those presently intoxicated from possessing a firearm. Overbreadth of the government's ban. During oral arguments, the Supreme Court justices criticized the federal ban because it applied to individuals regardless of where or when they consumed the drug. The law was deemed overly broad because it would permanently disarm a person who regularly consumes marijuana at a party, even if they never carry their firearm with them and safely stored it at home. In short, the ruling protects a marijuana consumer's general Second Amendment right to possess and carry a firearm, but it preserves the government's historical authority to criminalize carrying a weapon while actively under the influence. In this ruling itself, at one of the very bottom, I forget which justice it was, but they stated how many millions of Americans eat a gummy at night to go to sleep. How are they a danger to themselves? This is a massive win for the Second Amendment. This is a massive win for our American rights. This is a massive win for the gun trades. This is a massive win for cannabis consumers that enjoy the Second Amendment. And again, if you like the First Amendment, you should love the Second Amendment, and you should love all of the amendments, because that's what gives us our rights, and that's what prevents the government from infringing upon our rights. I just want to give this quick video breakdown again. Now, real quick, you still cannot buy a gun under what the context is right now in regards to the ATF Form 4473. Can't purchase a gun yet. If you have a gun, you're a cannabis consumer, you're allowed to have these weapons and be a cannabis consumer. Just don't be actively intoxicated. And again, like here in the state of Arizona, I've had two Pinal County attorneys, the previous Pinal County attorney and the current Pinal County attorney, on my podcast and specifically talked to them and asked them. You can go back through and look at my podcasts and posed this question to them. Hey, you get pulled, you go to the gun range, you're a responsible gun owner, you're practicing with your weapon to maintain proficiency. You swing by the dispensary on your way home, you pick up your gummies, you pick up your eighth, whatever the case is. You store your gun properly. You got your weed stored properly while you're driving home. There's no specific laws, but don't be stupid. Don't have it open next to you in the car. You get pulled over by Pinal County Sheriff's Office. You get pulled over by Gilbert PD, whatever the case is. Are you violating any state laws? And no, you're not violating state law. I'm not going to give that breakdown now, but you're not a prohibited possessor. You're not unlawfully using cannabis or anything like that. So therefore, you can, in fact, have these two things together. Again, not a lawyer. Again, not legal advice. Just telling you the words that they have said on my podcast and put it out there to the world. So I hope this clears things up. There's a lot more nuance involved with this. Let me know what you think of this video. Let me know if you have any questions. I could break it down a little further, but I just wanted to get this out there because this is a pretty exciting day for Americans. This is a pretty exciting day for those who love the Second Amendment. I love all of the amendments, and I think that all of our rights should be protected equally. Peace. Have a good one.